No videograph, no photograph. Ready. Yes.
Complementary list. Item number 1.
Yes. There's a supplementary list. Yes.
My lord, before my learned friend start, my lord, I have filed a caveat in this case. This is the issue pertaining to transfer of an employee, my lord, from one place to another place. The matter was before CAT.
5 years.
Right.
Outer limit is 5 years.
Lordship.
No matter of right, they have no right to claim to retain a particular place.
Yes, your lordship.
That's the order of the
I have filed a
client.
caveat, my lord. I am for the private respondent.
You're already party to the proceedings.
I was a party there in CAT.
Here?
Here also I am a party.
Okay.
I have filed a caveat.
Yes.
May I please, Your Lordship? Your Lordship, this is an application against the order passed by the Central Administrative Tribunal, Gratuity. What happened in this case, Your Lordship? I am a nursing officer working under the.
How long you have been there?
In my present posting, Your Lordship, 2 years, Your Lordship.
2 years.
Yes,
What
Your
is the right to continue?
Lordship.
What is the right? See the rule.
As per the clause D of the SOP, Your Lordship, which is at page 27,
You read it.
my transfer talks about rotational transfer, Your Lordship.
Huh?
So, as per clause D, Your Lordship,
Please repeat your argument.
my transfer, the transfer order, Your Lordship, which is at page 40, Your Lordship.
See, it is an administrative transfer.
Yes, Your
Your
Lordship.
case is that you should not be disturbed for a period of 5 years.
Yes, Your Lordship.
That's your argument. Please read the rule.
Transfer on rotational basis can be carried out on completion of tenure in a unit that is a wellness center, dispensary, or AD office. My post being a non-sensitive post, Your Lordship, my maximum period is for 5 years, Your Lordship.
Not so. You can be continued up to 5 years. Doesn't mean that you have got a right to continue for 5 years. Please read the rule. I think you have not read it correctly.
There's no minimum tenure provided, Your
That is
Lordship.
right. The maximum provided is the maximum you can be retained. It does not mean that you should not be disturbed after 2 years. The maximum tenure period for all posts in sensitive for serving in a particular wellness center will be considered in detail. For non-sensitive posts is 5 years. It cannot be extended. So it says maximum period is not minimum. Your contention is accepted, the minimum is 5 years. Don't disturb me for 5 years.
My another limb of argument is that, Your Lordship, I'm a mother of a 2-year-old child, Your Lordship. And as my working hour is from 7:30 a.m., it will be difficult for me, Your Lordship, to take my child along with me since I have no female member in the family.
It cannot be a ground. It cannot be a ground.
Your Lordship, here the right of a child, his fundamental right comes into play, Your Lordship.
Take 1993 3 SEC, Supreme Court judgment.
If I am transferred, Your Lordship, I will be forced to leave my child with my husband, who's only 2 years, Your Lordship.
See, you are on a transferable post. You have no right.
Yes, Your
You
Lordship.
cannot continue.
But on sympathetic grounds, Your Lordship, on domestic grounds,
We'll give you time. When are you willing to join the transfer place?
after 6 months, Your Lordship.
6 months.
Yes, Your Lordship.
She has already been released, my lord, by an order dated 27th of
Relieved.
released already.
Can you accommodate her for a period of 6 months?
Lordship, if I may, Lordship, she joined the CGHS Wellness Center in the year 2008, Lordship, in Shillong. And since then, she has been stationed in Shillong only, Lordship.
2008.
2008, Lordship. Since then, she has been in
15
Shillong.
years.
Lordship, more than 16 years, Lordship.
Your Lordship, I have been transferred, Your Lordship, in the year 2022, Your Lordship, from one wellness center.
Again, you will come back.
No, Your Lordship, from one wellness center to another, which is in Shillong itself, Your Lordship.
Why
Lordship,
don't you? 3
Lordship,
months. Willing to join 3 months maximum?
6 months, your lordship, if your lordship
3 months.
permits.
File an affidavit. Where is your client?
She's in Shillong itself, your lordship.
Ask him to file an affidavit.
Okay, your lordship.
Otherwise, we'll dismiss the matter.
Your lordship, 1 million number, your lordship. Initially, he was transferred, your lordship, but on
We went through the papers. It's there. No? Oh, yeah. Correct. 1993, 1 ACC 148. Judgment is against you. The order of transfer often causes a lot of difficulties and dislocation in the family setup of the concerned employees. But on that score, the order of transfer is not liable to be struck down. In a transferable post, an order of transfer is normal consequence and personal difficulties are matters for consideration of the department. Unless such orders are passed in malefice or in violation of the rules and guidelines, transfer without any proper justification, the court and the tribunal should not interfere.
Three months, then, your lordship.
3 months. Ask him to file an affidavit. You retain him for 3 months. You will not be, you are not going to be disturbed.
I mean, my lord, by this transfer order,
You are joined.
no, my lord. She has been released, and on her taking of a charge, my lord, I'm supposed to be released from.
Suppose we order notice and the matter is going to come up after 3 months, what will happen? Whether we give 3 months time to them to,
One thing your lordship will take note, my lord, this transfer order was issued in January 24.
January?
January 24. This
Doesn't
is
matter.
Almost 5 months, my lord. Could not
She's
make-
taking care of a child and mother-in-law, all those
In
things.
fact, your
So
lordship,
there is not a ground.
not a
Not a ground.
In fact, my
Sir,
lord,
even if we pass an order confirming the order of the tribunal, the court is empowered to permit her to join within a period of 3 months.
in fact, my lord, I too have problem, your lordship. That is
The reason why I am asking her to file an affidavit is that it will be a consent order. Having given an undertaking, she cannot go back.
In that case, lordship can dispose of now.
I must get an affidavit. Suppose she is conceded, the client may come and say that I have not asked the lawyer to concede. So better you strengthen your case. Ask him, can he come now? Half an hour time. We'll take it as the last case.
I'll call her up, your lordship.
We'll take it as the last case.
Lordship.
Dear blood.
Hello, my lord.
Yes. Yes.
From the daily list, item number 1. Yes, my lord.
Yes.
My lord, this is with regarding to regulations of
Madam,
market.
I think a similar petition is
Yes,
pending.
there has been.
How many PL can be filed?
No, my lord, we are not, all we're saying is that their PIL is to relocate. Our PIL relocate to makeshift markets. Our PIL is based on the fact that there are only 3 acts, 3 rules, my lord. The 2017, which was superseded by the 2018 rule, and now there's a Meghalaya Act.
You
also,
get
my lord.
yourself intervened in the other petition and contest the
But I will
matter.
not be able to ask prayers, my lord. There'll be, is our intervention application, my lord.
It's a public interest litigation.
I understand, my lord.
Prayer can be widened.
Then, my lord, it can be listed together.
No. See, otherwise everyone will file a public interest litigation.
But my lord, you please, if I may read,
Yes.
I'll begin at page 17, my lord.
See, if you have a case, straight away we'll grant.
Yes. See, my lord,
More so when other PL is pending.
yes, my lord, I need to say something. That PIL is lacking, my lord. And this PIL
That PL is?
lacking. There's certain things which have not been brought in that PIL. I don't have copies of that PIL, lord. My lord.
I will ask them to give a copy.
Yes, then, my lord, let me take instructions from my client with regards to whether he wants to be an intervener or whether he files a PIL.
So PL is between the court and the court will have to decide.
I agree, my lord. I bow
You
down. to
cannot say that you don't have a.
But my lord,
you are bringing it to notice of the court.
my lord, in this PIL, we are against relocation to makeshift markets. Why?
I think there is another matter pending, you know.
No, should be given the copy of the order.
I think several matters came up. We passed orders.
Yes, my lord, I can.
One minute.
It's there in my PIL also.
Rule number 18, that is livestock.
My livestock.
25 kilometers away it should be
Yes,
shifted.
but my lord, that law has now been diluted by 2018.
18 was what?
I'll read it to you, my lord. If you allow me, I will. If you go
Very
to,
well.
it is at page number, my lord. Page number 37.
37.
Yes, my lord. This is the 2018 rules, my lord.
1 minute.
I can begin at page 35, my lord, just to show you what is this rule about. This rule may be called the prevention. May I, my lord?
Rule 37 is the powers and duties of the chairman.
Yes, that is in 2017. Now I am coming back to 2018 rule, my lord, which has diluted 2018 rules.
Which page?
35, my lord. I begin at
35.
yes. I begin at 35, my lord. This rule may be called the
1 minute, madam.
Take your time, my lord.
There is no pagination at all.
There is, my lord, at the end of the page.
In our book, it's not there.
It can't be, my lord. At the end of the page.
Oh, yes, it's on the bottom. Yes.
Yes. My lord, this is annexed to
sorry,
4.
yes.
That's okay, my lord. The rules may be called the Prevention Cruelty to Animals in Animal Market Rules 2018. My lord, if I may just say one sentence before I begin. My lord, this PIL is not regarding
Where are you reading 35?
35, my lord, at the draft rules. It's written as draft rule
It
chapter
does not
1.
come into force.
My lord, they say that I will read the relevant portion to you. That in the first
Please
part,
answer our question, then you can address whether it is coming to force or not.
it is already notified, my lord.
Not yet notified.
Yes, it is in 22nd March 2018.
22nd March 2000 is draft rules.
Which is, let me read, my lord, let me read, so you will understand.
Yes.
The draft rules will be taken into consideration on and after the expiry of 30 days from the date for which the copies of the Gazette of India containing this notification be made available to the public. Okay. So, my lord, they also have asked for comments with regards to these draft
That is
rules.
a general procedure.
Yes.
Followed. Yes.
So now, my lord, with regards to this rule 2018, if you turn to page number 36, my lord,
Yes.
at section 4D.
Yes.
May I read, my lord?
Yes.
Take all necessary steps to ensure that no animal market in this jurisdiction, if such jurisdiction includes an international border, in the source of transfer of animals across. This is diluted section.
Rule 4 is the functions of the committee.
Right. But it also speaks about, my lord, it doesn't speak about the distance from the borders anymore, except for international borders. And now if you see Rule 8, my lord, which is also a dilution of Rule 8 of 2017. I will compare.
Madam, how can you challenge the draft rules?
No,
Unless it is
so, my
notified.
lord, I'm just showing you, my lord. I'm just showing you. Rule 8, my lord, which says that animal markets near international borders, that is the only distance, my lord. I'm showing you, my lord. Then I will come to another act which the state government has a bylaw. This is the Meghalaya Act. May I, my lord? If you have understood Rule 8. May I read? But first, I'll read Rule 8 to you, which is at
Yes.
which is at page 37, my lord.
Yes.
Which says that animal markets near international borders. It does not specify the distance or the state borders. Now I go to the Meghalaya Act, my lord, which is at 2020. This is only notified, my lord. This is the state bylaws. It begins at page 44. I will tell you the title of the act.
Page 44.
44, my lord.
Huh.
The Meghalaya State Agriculture Produce
Yes.
and Livestock Marketing, Promotion and Facilitation Act, 2020. This is the State Act.
Yes.
Now, my lord, if you please may go to page number 50.
50?
50, my lord. This act is silent on prevention of cruelty to animals. It's completely silent. Now, if I may read establishment of markets. Rule 3, section 3.
Yes.
So the state government may, it says may, by notification in an official gazette, declare its intention of regulating markets of such agriculture, produce and livestock in the state as may be specified in the notification. There is no notification till date, sir. My lord, for relocation to makeshift markets. Yes? So my lord, this act is silent on prevention to cruelty. We're only saying that these makeshift markets, if markets are relocated, then my lord, prevention
Yes.
to cruelty cannot be regulated. I mean, there are illegal transportation of animals which do not follow the 2001 Act. Yes, so there are only three rules that I've already shown you: one act and 2 rules. Now, my lord, my petition is.
Yes.
My petition is, my lord, these makeshift markets have no housing or shade or feeding trouts or lights, that is electricity, or ramps for the height of the vehicles, no provisions for parking place, no veterinary hospital, doctors available on these new locations.
What is your earlier writ petition, sir, pertaining to whether,
But Worship, I'll just clarify.
see, previous rule says you should keep it away, that is 25 kilometers away from Shillong.
Worship, in the previous PIL, the petitioner came before the court asking to enforce Rule 8.
Old Rule 8.
Oh, Rule 8. And their whole plea was, Lordship, that, government should take steps of removing from the border and international border 25 kilometers. That was the Rule 8. And Lordship, for clarity, we can just take your Lordship, the Rule 8. So that has been directed by 2018. The case of the petitioner, the state government should enforce. Now, Lordship, this rule is framed under Prevention of Cruelty Act, Section 38, 1 and 2. And this is the central legislation.
Madam, how can this prayer be granted in the PIL?
So my prayer.
See, if you want, we'll give you permission to get yourself impleaded and contest that matter. Otherwise, we'll dismiss it. And in the interim prayer, you are seeking for the stay of the enactment.
No, I'm not asking to
See,
stay. No,
see the
my,
prayer.
I will read my prayer. I will read my prayer, my Lord. I am not asking for a stay of enactment. I am asking you, my Lord, my humble prayer is to please stay the relocation of markets, my Lord. I will read my prayer slowly, my
Yes,
Lord.
yes.
The relocation of markets.
And establishing animal markets in violation of Rule 2018.
For relocating, to stay the actions of
That is 2018 has not come into force. So and so, livestock and promotion during the PIL.
Yes, my Lord. So what I'm saying, my Lord, is that there are only three. See, 2018 is only come into play, my Lord. There are only three rules, my Lord.
Lordship, if I may submit,
We are only.
We are not agreeing with you, madam. We are going to dismiss the matter. That's all.
Then allow me, my Lord, to implead myself as a.
That's what we said. That's what we said. The petitioner has come forward. The following prayer. Inner page 13. Already writ petition number so and so, PL, is pending.
Oh.
Full stop. The main ground of attack in the present writ petition is that though the distance is specified in the old enactment, the rule published in the Government Gazette, Gazette of India, dated 24th March, so and so, clearly states that it is a draft rule and that objections have been called for. Full stop. According to the petitioner, in the draft rules, also in rule number 8, that deals with animal markets near international border, no other provisions have been made with regard to maintenance of distance. She would further contend that in terms of the Meghalaya State Agriculture, Produce and Livestock Marketing, Promotion and so and so Act 2020, published in the Gazette of Meghalaya, Part 4, dated 1st June 2020. Rule 3 deals with the establishments of market, more so with regard to the intention of regulating marketing of specified agricultural produce and livestock for which a notification has to be issued.
Yes, my Lord.
According to her, even though the act has come into force, as on date, there is no notification.
Yes, my Lord.
Full stop. The petitioner in the prayer has specifically sought that there should be prevention from relocating or establishing animal markets at places like so and so village, not conducive for the location of a livestock market. Full stop. Mr. Khan, Additional Advocate General would submit that the petitioner has already approached this court by way of PAL number so and so, wherein they sought for relocation of.
No.
You come, no? You said
No, Lordship, not the present petitioner, other petitioner,
some other petitioner.
some other petitioner, not she.
Then you must change it, sir.
Yes.
Another petitioner has approached this court with regard to shifting of the livestock in terms of Rule 2017 and a distance of 25 kilometers from Shillong to be maintained. Full stop. As the rule have not come into force and that there is no time limit prescribed in terms of section 3, which is extracted supra, we are not inclined to grant the relief as such as prayed for by the petitioner. This court has expressed a view that it is open to the petitioner to get impleaded or but intervener in the writ petition number so and so PL pending in order to put forward the case. Full stop. Though the counsel vehemently addressed argument, when this court expressed that the relief cannot be granted in this writ petition, she sought permission to get herself impleaded in the writ petition number so and so. Taking note of the submission, the writ petition is disposed of, giving liberty to the petitioner to get impleaded in the writ petition pending. Writ petition number and all you give.
I'll give you, my lord, it's here. It's PIL number 7 of 2023.
Yes.
Lordship, small clarification, I just heard it, if I'm not mistaken. 25 kilometers from state and international border, not from Shillong.
25 from state to international.
State and international.
Yes.
Item number 2.
What's the obligement?
Yes, sir.
Yeah, please. Lords, petitioner before my lords is a PSU, my lords. Admittedly, they have paid the tax on their purchases.
Admittedly,
They have paid the tax on their purchases. My lords are aware that when I purchase on the payment of GST, I am eligible for input tax credit. My lords, the mechanism is that whatever input
what is
tax.
the grievance here?
Yes, my lords, the grievance is that they are saying merely because I filed the returns delayed. Therefore, I will not get the IT.
Is it not an appealable order underneath?
It is, my lords. The order is appealable, but the relief which I am seeking is because I am also seeking quashing of notification and implementation of notification.
All those things can be changed.
Lords, what is happening?
You prefer an appeal.
Lords, I am before 4 other high courts, and if my lords would allow me, I will only show to my lords that what is the problem coming.
Guwahati and Jharkhand.
Yes, my lords.
Guwahati High Court and Jharkhand.
That's right, my lords. And Guwahati, my lords, both, my lords, the Itanagar as also, my lords, the principal bench is Guwahati. And the problem is this, my lords. We have already paid the entire tax. Why this problem is coming? My lords, initially they said that there will be a form GSTR 2 and GSTR 3. That is notified form. But they were unable to bring it on the portal. It was a technical glitch there themselves, GST Council.
You are trying to circumvent your deposit.
I am not at all. I have paid full, my lords. There is no circumvention at all.
Penalty is there. Penalty is there. Penalty also you have paid.
No, my lords, I am saying that the reason on which this demand is based, I have paid the entire tax. It's only a technical issue. If my lords would permit me, well, I'll show those 1 or 2 things only. If my lords
On
would,
the other side. Then you deposit 10% of the amount.
if my lords, after hearing me, if my lords would say, I'll certainly deposit. I am not.
Interim order will give you. Will give you on condition that you have to deposit 10%.
Lords, this is the loss-making PSU. If my lords would only permit me, my lords, this is a very genuine difficulty. I have paid entire. My lords are asking me to deposit 10%. If my lords would say, I will still persuade my client to pay because it is falling from my lords. But if my lord would see why my lord the other courts have my lord granted relief is because of a problem which has arisen admittedly on their part. If my lord would permit, I'll just show to my lords.
Subject to correction, one case
Yes, my lord.
gone from the order of the tribunal. Correct?
In no, my lords, in none of the case we have gone against the order of the
See,
judge.
now the Assistant Commissioner has passed an order.
That's right,
In
Lord.
terms of the commission, in terms of the Act 108, you have got a proper right of appeal.
But not for implementing the notification, my lords. That I will not be able to get. Otherwise, I would not have bothered my lords. If my lord would kindly see,
Admit interim order on condition that payment of rupees.
my lord, only if my lord would permit me.
Granting interim order.
My lord, I am
You
only-
can't say what interim order we should grant.
I am not saying that, my lord. I am saying I will deposit. My
This
lord,
is the uniform order we are passing. This is the uniform
my lord, for
order.
my satisfaction, my lords will just see that. Thereafter may pass this order, I have no problem. I am not saying, my lord, may not. If my
This is
lord,
the order we are going to pass.
my lord, I am saying.
You see, we have read the papers.
Yes.
We have read the that's a problem.
Yes, my lord.
When we read and come, you will have a problem. We don't have, yes,
My lord, give me only 10 seconds.
not required, yes, admit.
My lord, my problem is, my lord, we are a loss-making PSU, my lord. That's why I am saying, my lord. The government money is secure, my lord.
That's why he's saying the 10%.
The government money is secure, my lord.
Admit interim order on condition that the petitioner shall deposit 10% of the amount as per the orders of the Assistant Commissioner for Labour. Assistant Commissioner.
All right, my lord. This is, yes, my lord.
The notice also, this is without prejudice to the contention to the other side, or contention of the other side,
Extension.
to raise an objection with regard to availability of alternate remedy. Yes.
My lord, this is, my lord have passed this order. My lord may permit one thing I want to show to my lord.
Yes.
So that my lords may ask them, give them a direction to just bring that on record when they file a counter.
Yes.
My lord, you just see annexure P. My lord, this is the problem why I am facing this entire problem is, my lord, this is a notification, my lord, sees this at page 250, my lord.
215.
2250, my lord.
250. Yes.
My lord, just see the foot of the page, my lord, para 2. My lord, they say the extension of time limit for furnishing the details or return as the case may be under subsection 2 of section 38 and 39(1) for the months of July to March shall be subsequently notified in official gazette. My lord, they are saying that I have not filed in time, whereas 4 times they have said that the date shall be subsequently notified. And they don't notify it. This notification is in force and they don't notify the extended date. If they would have notified it, I am in time, my lord.
What is
This
it?
is the only problem, my lords.
Lordship, I'll take instant.
4 times, my lord. 4 notifications. My lords may just turn over the page and see.
P.
Yes, my
Give
lord.
page number. The respondent is expected to answer with regard to the notification as contained in Annexure P, page number 250 of the typesetter paper.
My lord, the same thing they reiterate on page 251 again.
Yes.
Because their portal was not functioning. They are today denying me credit. Their portal was not functioning. They acknowledged it.
But anyway, it's part of Form P only.
That's right, my lord. Annexure P. Notification after notification, they kept on saying this.
Yes.
That's why, my lord, I am saying that I have paid the entire actually, but still I will pay, my lords. My lords have said. But in that case, my lord, my request would be, my lords, may ask them to, my lords, file it in a shorter date, and my lords, I will argue this matter, my lords.
Amount to be paid within a period of 4 weeks from the date of
My
receipt.
lord, don't fix the time for pay, I'll get it paid. I am saying,
I'll give you outer limit. You pay tomorrow also.
Yes, yes, sir.
In a period of 4 weeks means.
But, my lord,
tomorrow you can pay.
yes, my lord.
When you file your objections.
3 weeks time, Lordship.
My lords may fix it for final hearing in June, my lords. If my lords convenient to my lords, of course, my lords.
1st or 2nd of July. Yes.
Grateful, my lords. 1st July, my lord?
1st or 2nd of July. Monday, Tuesday.
Yes, yes. First is fine.
Item number 3.
Great, my lords. Great. Oh, my lord.
Yes, you've been, how is the writ appeal maintainable?
My lord, here I have formulated 2 issues, my lord. 2 issues. The one issue is, my
How
lord,
can we overcome 212? Article 212.
212, my lord. Yeah, exactly, that is what I wanted to issue, my lord, frame the issues. When, my lord, the decision of the speaker, my lord, is in violation of the constitutional rights and also and the rules of statute, my lord, then, my lord, there is no bar for the judicial scrutiny, my lord.
You are ready, Mr.
This is an
I'm ready, my lord.
admission hearing.
I'm ready, my lord.
I'm ready, my lord.
So, my lord, why do I say why? And then the second is, my lord, thus Article 212 gives an absolute immunity, my lord, to the decision of the speaker, even if the decision is beyond procedural irregularity, my lord. If it's a procedural irregularity, I understand, my lord. Article 212 protects the decision or the proceeding. We cannot question the validity of the proceeding, my lord. But then, when it comes to the violation of the constitution, constitutional rights, or the rule of the statutes, my lord, then, my lord, that judicial scrutiny, my lord, the speaker is not immune from judicial scrutiny, my lord. Here, what had happened, my lord? The governor tables the report of the PSC to the legislature in terms of Article 151, my lord. Now, 151 article says that the PSC report, the Comptroller and Auditor General's report, shall be submitted to the governor, who shall cause the report to be tabled to the legislature. After that, then it becomes silent. What is to be done with that report? It becomes silent. Now, my lord, Article 208. Article 208 gives the power to the state legislature or to the parliament to frame the rules of business. Now, when in exercise of Article 208, the Meghalaya Legislative Assembly, the legislatures, have also there framed the rules, my lord. Now, Rule 130A. Rule 130A says this: when a report or any matter of public importance is tabled in the assembly, my lord, then any of the legislature can move a special motion for discussion, my lord. This is now, is the government saying the report, this report, is it excludes or doesn't come under the PSC report or the controller or I'm sorry, the word I'm just misusing, PSC, it's not PSC, it's a Comptroller and Auditor General's report. Is it not a report? Of course it is a report, because that has been caused by the governor to be tabled before the assembly. And what does that report says, my lord? Now we understand, my lord, what we, Meghalaya, my lord, we are a non-tax paying state, my lord. Indirect taxes are there, but wealth taxes and income taxes, we are not paying. All the money, the funds that we depend is on the tax-paying states, my lord. Now the Auditor General tables a report and says that 156 crores could have been avoided. There was a suggestion, there was an advice not to go for certain NIT or certain contract allotment of certain contracts by the Meghalaya Power Department, my lord. Yet they went ahead, and the controller said that this expenditure could have been avoided, my lord. So as a legislature, my lord, when these reports are there, my lord, which concerns great public importance, my lord, and this needs to be debated. Why it needs to be debated? Because so that we can bring some kind of rules or some kind of amendments in the future, so that where we can curtail this kind of unwanted expenditures, avoidable expenditures. This is my motive of bringing and moving 130A, my lord. Now, my lord, what happens now? The Chief Minister writes a letter when I have moved my motion, or when I have submitted my notice. Chief Minister writes a letter to the Speaker saying that this issue is under the consideration of the Public Accounts Committee. Therefore, do not allow him to raise this issue, reject. On the basis of that, my notice gets rejected. Now, I'll just pause here for a moment. Who is this PSC, my lord? This PSC, my lord, it's, with due respect to the PSC, it has been created whenever the government is about to face some kind of embarrassment, they hide under the shelter of PSC. This is what they try to do exactly in the airport matter also, my lord. And this, I'll just place one order where my lords has passed. And then only, my lord, the PSC had to go away from interfering in the airport matter also, my lord.
Yes.
For a moment, my lord, kindly look at this, this order which was been passed by my lords in the sitting as a full bench, my lord. May I read from the paragraph number 2, my lord, or paragraph number 3 for Learned Advocate General, my lord, from there. Learned Advocate General Meghalaya, on the instructions of the Deputy Commissioner Mangpo, Reboi District, present in court, submits that the building which are impeding the projects of expansion of Shillong Airport, pending sometime since 1960s, have been illegally constructed after payment of compensation, and the authority has already given eviction notice to such unauthorized occupants. However, on account of interference by letter dated 03/08/2015 by the Public Accounts Committee, the eviction process could not be completed. But as per the letter reference dated 14 October, submit that during the course of the hearing, the aforesaid letter of the PSC has been withdrawn. Why they were asked to, why they did withdraw here, my lord? They tried to interfere when the court was proceeding the public interest litigation for the expansion of the airport. PSC tried to interfere, tried to cause problem, my lord. But when my lords have come down heavily, they immediately withdrawn, my lord. So here, also, my lord, when I wanted to debate, when the legislature wanted to debate, 156 crores. Chief Minister says that no, it's in the PSC, don't let him discuss this. Why? So when the Honorable Speaker was rejecting my notice, my lord, was influenced.
Now, how can we say
Yes, my lord.
that these questions can be raised or not
Yes.
by judicial intervention? How is it possible?
Yes, my lord.
More so in light of 212 is our question.
My lord. Here now, my lord, what I say is now, constitutional right, what Article 194 gives the legislature, 194, we just have a look once, my lord.
Yes.
This is where I say my constitutional rights violates. Article 194 is of privileges of the members. It says the clause 4. It says the provisions of clause 1, 2, and 3 shall apply in relation to persons who, by virtue of this constitution, have the right to speak in and otherwise take part in the proceedings of a house, of a legislature of the state, or any committee thereof, as they apply in relation to members of the legislature, my lord. So, my lord, now I am exercising my constitutional right as provided under Article 94 or 194. And also, my lord, Article 19, my lord. Now, these rights gets abruptly curtailed. So, this is the violation of constitution, the constitutional rights. And, my lord, now about the rules statute. Article, as I've just to reiterate myself, my lord, Rule 130A, the conduct of the proceeding and the conduct of business rules, my lord, is the product of Article 208. And 130A very clearly gives, 130A, my lord, will just...
Yes.
It is-
33.
Yes, my lord. (130A), my lord, it says, whenever any report or any matter of urgent public importance and of a recent occurrence is brought before the House, any member can move a motion for discussion on that matter. Such motion will get precedence over motions under 131. The Speaker shall fix the time and date for discussion of two things. Report, my lord. Whenever a report is placed, the report was already placed on the last day of the report was already placed on the last day of the autumn session 2023, my lord. And we were sitting as a budget session after 6 months, my lord. So on the last day, when the report was tabled before the legislature, nobody could have get that opportunity to
What do you
raise
say, Mr. Amit?
Yes, my lord. Your lordship, there are two submissions, my lord. First, my lord, your lordship has said that there is a constitutional bar under Article 212, my lord. Kindly see Article 212, my lord.
Yes.
Courts not to inquire into proceedings of the legislature. The validity of any proceeding in the legislature of a state shall not be called in question on the ground of any alleged irregularity of the procedure. No officer or member of legislature of state in whom powers are vested by under this constitution for regulating procedure or conduct of business or maintaining order in the legislature shall be subject to jurisdiction of any court in respect of exercise of those powers. So Article 212, my lord, clearly bars the jurisdiction of this honorable court or the court to inquire into the proceedings, my lord. That is the constitutional bar under Article 212. This is my first limb of the submission, my lord, and I am supported by recent judgment of the Honorable Supreme Court, my lord, which has been referred to by the learned single judge in the impugned judgment, my lord. Kindly see the impugned judgment, my lord.
You say the citation.
Yes, citation is, my lord, 2024, 1 SEC, page 384, my lord.
Okay.
And kindly see the page 53, where the relevant page 55, my lord, where relevant paragraph of that judgment has been quoted.
Para?
Page 57, my lord. Page 56 is the paragraph 11. Page 56, paragraph 11.
Single judge judgment.
Yeah, learned single judge judgment, my lord.
Yes. Para?
With regard to the paragraph 11, page 56, my lord. With regard to the instant case, as no situation exists to hold that there has been substantive illegality, no judicial review is called for. Decision cited by respondent in the case of State of Punjab versus Principal Secretary to Governor of Punjab, however, is useful with regard to exercise of power by the Speaker to regulate the procedure of the House, and binding nature, the decision of Speaker has on every member of the House. Paragraph 40, 41, 42 thereof in this case are quoted herein below. The Constitution and established legislative practice distinguish between adjournment sine die and progression of the session of the House. In the case before the Vidhan Sabha was adjourned on 23rd March 2023 without prorogation, therefore, Speaker was empowered to reconvene the sitting of the House within the same session. Now, title, my lord, exclusive domain of Speaker to regulate the procedure of the House. Under Article 178 of the Constitution provides for office of Speaker and Deputy Speaker of Legislative Assembly. Article 212 of the Constitution precludes the court from inquiring into proceedings of legislature of the state. A corresponding provision with regard to the Parliament is contained in Article 122. The decision in Ramdas Athwale is significant in that it dwells on the role of Speaker of the House and interprets the Article 122 of the Constitution. Constitution bench observed the Speaker is the guardian of the privilege of the House and the spokesman and representative upon all occasions. He is the interpreter of its rules and procedure and is invested with power to control and regulate the course of debate and to maintain order. The power to regulate the
Yes.
procedure and conduct,
Yes.
Milord, and now kindly see 194, Milord,
That
what
is
my
right.
friend has
194.
and Milord, 194, Article 194, Milord, kindly see, my friend has read only 194.3. Kindly see 194.1, which my friend should have also read.
Article.
My friend did not read that, 194.1. Milord, the subject to the provisions of this constitution and to rules and standing orders regulating the procedure of the legislature. There shall be freedom of speech in the legislature of every state, Milord. And article, Milord, rules have been framed regulating the speech of the members, Milord. 194.1, and kindly see the rules. My friend has quoted only part of the rules, Milord, but that is also sufficient. Kindly see Rule 131, which is page 33, Milord, of the 33 of the paper book, Milord.
Yes, yes. Same page 33.
And yeah, 133, Milord, and 131. Discussion on a matter of public interest by motion, save in so far as is provided by the Constitution or by these rules, a motion on a matter of general public interest can be discussed only with the consent of the speaker. So the speaker is the guardian, Milord. And kindly see one more rule, Milord, which is important, 241, which 241, Milord. 241, that is there. My friend will circulate. I have placed that rule separately. My colleague will place, Milord. Committee on Public Account.
One.
Milord, under that rule is not there on the record, Milord.
Yes.
241, Milord, kindly see. 241 of the Meghalaya Legislative Assembly rules, Milord. Page 79, Milord, of page 79. There shall be a committee on public account. Rule 2241, Milord. There shall be a committee on public account for examination of accounts showing the appropriation of sums granted by Assembly for expenditure of the government of Meghalaya, the annual finance accounts of the governor of the Meghalaya, and such other accounts laid before the Assembly as the committee may think. In scrutinizing the appropriation accounts of the government of Meghalaya and the report of Controller and Auditor General, it shall be duty of committee to satisfy itself. So report of Controller and Auditor General, Milord, shall be placed before the Public Account Committee, consisting of, Milord, members of the opposition as well as members of the ruling government. 242 is the rule, Milord, which is at page 80. Page 80, Milord, 79, it is in the
Page
booklet
which?
form, Milord.
Page
Page
80.
80. 80, Milord, 80.
Oh.
It is above 79, Milord. The pagination is because of in booklet form. It is just above 79, Milord.
Wow.
242, Milord.
28. 80 is here, but 53.
242, Milord. The Public Account Committee. The committee shall consist of not more than 10 members who shall be elected by the House from amongst its members according to principle of proportional representation by means of single transferable vote. So the constitutional scheme, Milord, is that whenever a report is under Article 151, report of CAG is placed, it is placed before Public Account Committee. And Public Account Committee will examine, it will submit the report in the Assembly, and then thereafter the discussion will take place. That is the procedure, Milord. Now, Speaker and exercise of power under 131(4), Milord, of the Meghalaya disallowed the application on the ground that the matter is pending before Public Account Committee. Now, this is a procedural matter which is governed under Article 212, and the plea that under 194, the member has got unfettered power to discuss the matter is also subject to the rules and regulation, Milord. And there are constitutional judgment, and all these judgments, my lord, clearly say so. And kindly see the prayer in the kindly see the prayer in the writ petition at page 29. What is the direction which is being sought from this honorable court, my lord? Page 30, where page 30, first prayer 29, my lord. To issue a writ of quo warranto to the respondent for the impugned decision to disallow the discussion or report of controller during the assembly session of the Meghalaya Legislature. To issue appropriate order or injunction to restrain the respondent from curtailing constitutional right. Under Article 1, under 19(1)(a) and 91(194) of during the assembly session. Third, my lord, to issue necessary order or direction to the respondent to comply with Rule 130(a) of the Rules for Procedure and to allow a special motion to be moved by petitioner to discuss CAG report. What is being sought, my lord, is the direction by this honorable court to Legislative Assembly to regulate its own procedure, which is clearly barred by Article 212, my lord. And there are three judgments, my lord, on which this point, which have been referred to me, including Constitution Bench judgment, my lord. First judgment is 2010 4 SCC, my lord.
No, what is that? What is that?
2010 4 SCC, page 1.
2010 4 SEC, page 1.
1, my lord. And 2014, the other judgment is 2014 2 SCC, page 178. And recent judgment is, my lord, 2024 1 SCC, page 384.
2024?
2024 1 SCC 384, my lord.
That you have referred already.
Learned Single Judge has referred to all three judgments, my lord. Kindly see what is the submission of my friend before Learned Single Judge. Kindly see the impugned order, which is under challenge before your lordship. Kindly see what is his argument before the Learned Single Judge at page 50, my lord. Page 50. 50, my lord, of the writ appeal, my lord. Paragraph 3, my lord. Learned counsel for the petitioner, Mr. P. Yobin, while referring to Article 212, has submitted that writ petitioner has not been filed on the ground of any alleged irregularity of procedure, which would surely bar the jurisdiction of the court, but challenge he contends is directed against the action of speaker in curtailing the right of petitioner as given in Article 194(1) of the Constitution, my lord. So 194(1), my lord, subject to procedures and rules framed by Legislative Assembly, my lord. This is first argument.
Ultimately, Speaker, in terms of Article 194(1), the Speaker must agree.
Yes, yes, my lord. And that procedure is, and Speaker has the power to and regulate it because rules have been framed Meghalaya Legislative Assembly. Now, the second argument my friend says, my lord, he further submits that there is no rule regulating the procedure of Meghalaya Legislative. This is completely wrong, my lord. The rules are there, which restrict the discussion on report of CAG, which would qualify condition, my lord. And then, my lord, my judgments, I have referred three judgments, my lord, which have been referred by Learned Single Judge at page 53, my lord. First, Learned Single Judge refers to Article 212, my lord. Page 53, paragraph 6, my lord.
Page 53.
Yes, paragraph 6, my lord. The reference is to Article 212 and the finding is, my lord, at paragraph 7, my lord. As can be seen, the article has clearly put an embargo on courts to look into the validity of any proceeding legislature of state on the ground of any alleged irregularity. Instant case writ petitioner has invoked 138 to press the demand for special motion. Now, my lord, kindly see paragraph 8 finding thereafter. The above no doubt allows any member to move a motion for discussion on such matter. As matter of procedure, request has been taken up, which however was denied on the ground that subject matter was under the examination of Public Account Committee of Meghalaya Legislative Assembly, which is evidenced by a letter of 19 February 2024 under the caption disallowed motion. Though it is correct, the challenge not on the ground of irregularity procedure, decision of speaker, however, cannot be said to be unconstitutional to warrant judicial review, notwithstanding submission that subject matter involves a matter of grave public interest, my lord. Though reference has been made to Article 194(1) of the Constitution to try and impress upon the court that right of the prisoner has been curtailed by the Speaker, thereby making the decision unconstitutional, it is to be noted that Article 194(1), though providing for freedom of speech and listed the same is, however, subject to constitutional rules and standing orders regulating the procedure of this. So my submission, my lord, is that learned single judge has correctly applied the law, referred to relevant judgment and relevant statutory provisions, and came to right conclusion, my lord, saying that the writ petition is barred by Article 212 and the rules
Yes, sir.
and the
Yes, Mr. Robin.
My lord, just a very quick rejoinder, my lord. First, the learned AG has taken to 313 and the 241 of the rules and procedure, my lord. Now, rules 214, just
241 or 214?
241, yes, 241, my lord.
Is the rule.
The rules of the business, my lord, of the procedure and the conduct of business rules, my lord. Now, neither rule 241 only talks about the functions of the committee, and 242 talks about the constitution of that committee, my lord. And nowhere there is a restriction given that when the matter is examination of the Public Accounts Committee, that the subject matter cannot be discussed in the floor of the House. Can they show that? There is nothing.
Yes.
Now, my lord, Article 212, my lord. Article 212, it bars only question to a procedural irregularity, my lord. It's not a blanket ban. When I am alleging, yes. Take out 212.
221 is a bar only for procedural irregularities.
Procedural irregularity, my lord. It does not give an absolute immunity, my lord. When it does, and now, my lord, the learned Advocate General has referred to Article 194, Clause 1, my lord. Clause 1. Two things that I have to, this is what has been argued, my lord, before the Uttarakhand High Court also, my lord. And Uttarakhand High Court were taking reference of some of the decisions, cutting of decisions that already been pronounced by the Honorable Supreme Court, comes to a conclusion, and I'll just read for my lord's benefit, my lord. Quote, the position of law can be summarized as that Article 212 is intended to protect the legislature and the officers of the legislature when attack is made on the ground of irregularity of procedure. It would not offer a shield when what is at stake is action which is in violation of constitutional guarantees or of mandatory provisions of a statute. My lord, be as it may, my lord, today, the Advocate General has referred to a cutting of judgments, my lord. Today, since it's an admission hearing, my lord, let it come for a full-fledged hearing.
Full-fledged hearing.
My lord, I'll study the judgments that...
all those judgments are already there.
Already the learned judge has quoted.
My lord, I understand that, my lord, but there are some points that, my lord, which is, just to be very honest, I have, that's in my bag, but it's not coming out, my lord. But I know, this is a very important, of course, all the cases are important, but this, I feel, my lord, this is one of its kind, my lord. one of its kinds in the history of Meghalaya High Court.
Exceptionally important.
I wouldn't say that, but one of its kind,
Political
first
violence,
time.
my lord, sometimes it is for public consumption also, my lord. Sometimes nowadays public
We heard you
consumption
for
and
more than half an hour.
My lord, my lord.
What is there?
my lord,
If you have any doubt, he'll ask you. If you have any judgment circulated,
Judgment circular, my lord, this judgment that I have just referred, my lord, his lordship, my lord, has at paragraph 4 make a reference of it, my lord, but has not given the quote of the judgment, my lord. So, my lord, to the words of my handicap also, my lord, I have just one set.
when are you coming, Mr. Amit?
I will be there, my lord, next week. After 7th, I will be there, my lord.
Let's have it
8th,
after
9th,
that, my
10th.
lord. Let him come personally also. In the meantime, we will, my lord, it's a very interesting, I know, my lord, I know where I stand, my lord. It's a very thin line, my lord.
No, that is right. So you are asking us to cross the Lakshman Rekha. That's all. So you are asking us whether we have to cross or we have to erase it and enter. That has got to be decided.
One of my junior asked me, Lord, one of my junior asked in Meghalaya, what is Lakshman Rekha? So I explained to him, Mr. Arkin Kharwanglang, what is Lakshman Rekha? That is, I told him the story of Ramayana. That is, your Lordship may have it on 9th, my Lord. 9th and, 10th, my Lord.
9th and 10th.
10th is Monday, my Lord.
10th, my lord.
My friend.
12th.
My lord, I am deeply obliged, my lord. Patiently heard me, and then another date, my lord, will.
So the request of the petitioner, the matter is heard in detail. The counsel for the petitioner would submit that he will go through the references cited by the Advocate General and also produce authority in support of his contention. 12th.
Grateful, my Lord.
Deeply obliged.
Item number 4.
May I please, Your Lordship? Your Lordship, the conducting counsel is indisposed, Your Lordship, today. So I pray that the matter be taken up
Sir?
next week. Your Lordship, the conducting counsel is indisposed, Your Lordship, today. So I pray that the matter be taken up next week, Your Lordship.
Item number 4.
Yes, Your Lordship.
What is the matter about?
Regarding gratuity, Your Lordship.
What is it in the challenge? What is it your challenge here?
Lordship, this matter had already been decided in the last date, and we have complied with it. If I may kindly take you to page 56.
So with regard to the payment of gratuity?
Yes, Lordship.
Yes, Your Lordship.
Yes.
Your Lordship, I just pray that the matter be taken up next week, Your Lordship.
No. We are reading and coming. It is your duty to read. See, I've been repeatedly telling the juniors, read and argue the matter. See, you have challenged the regulation. See, the matter should have gone before a single judge. Because you have challenged the regulations, gratuity rules of 1980, Meghalaya Municipal Board gratuity rules you have challenged, 1980. That is the reason why the matter is posted here. What is it you want? What is the relief you want in this petition?
Because till now, Your Lordship, they said that they have implemented the Payment of Gratuity Act, which that rule also still exists, Your Lordship.
Rule?
Rule, Your Lordship, the gratuity
We'll
rule.
accept your rule. We'll accept that the rule is set aside. What will happen? We'll
Yes,
say that we are quashing the rule.
Your Lordship, but then, Your Lordship, we are praying that, Your Lordship, that Payment of Gratuity Act should be implemented by Section 4.5, Your Lordship.
Section 4.5.
Yes, but they are implementing only
How
Section
are you entitled to under Section 4.5?
because the award was already passed, Your Lordship.
That is the award. What is the benefit given
My
under the
benefit is
award?
that, Your Lordship,
You are referring to 1971 award, is it
yes,
not?
yes, Your Lordship.
What is that status?
It says that in that award, Your Lordship, it says that the Shillong Municipal Board, Your Lordship, are entitled to 30 days, Your Lordship, 30 days employee gratuities in one.
30 days they are entitled to.
Yes. But
1
as,
month.
yes, as per
30 per year.
yes, Your Lordship.
Where is that?
Page 24, Your Lordship, that one.
24.
24 years. Cyclopean is annexure, page
This is
29.
award is
The
there?
award, Your Lordship.
1971 award, yes.
Cyclopean is to 29, Your Lordship.
Page number 29. And that you typed it. Where is it mentioned as 30 days?
Page 30, Your Lordship, which is in paragraph 2.
Huh?
Page 30, which is in paragraph number 2.
Page number 30.
Yes, 30, Your Lordship.
Oh.
Paragraph gratuity at the rate of 1 month pay on the basis of last paid run should be granted for each complete years of service with immediate effect, Your Lordship. So the award was
1 minute, 1 minute. This is as per the award.
yes, Your Lordship.
Award is in force.
Yes, Your Lordship.
Yes, very good. Then, which portion of the rule you are challenging?
The rule of section 3 subsection.
Section, where is that?
Sub, page 64, Your Lordship.
64.
64, yes.
Ah. Rule shall come into effect immediately, yes. Rule 15 of Meghalaya Assam zone, though. So the Meghalaya Municipal Administration here with the following rules. Yes. This is 1980. Where is it mentioned?
In paragraph 4, Your Lordship.
Paragraph?
Subsection 4 and section 3, Your Lordship.
Rule 4.
Yes.
This is rule.
No, rule 3, subsection 4.
Rule?
Rule 3.
Rule 3,
Yes.
subsection 4.
Yes, Your
Oh, sorry, sub-rule 4.
Yes, Your
Gratuity?
The amount of gratuity will be done 1/4 of the emolument of
Will be done fourth of, what is mean, done fourth?
1/4.
1/4, Your Lordship, actually.
Oh, will be 1/4 of the emoluments of the officer
For each completed 6-month leave period of qualifying service subject to a maximum of 16 one time of his emolument.
So they are going to give you 1/4 of the amount
Yes, Your Lordship.
of your salary.
Yes, Your Lordship.
Almost that is only 25%.
Yes, Your Lordship.
Is it?
Only 15 days, Your Lordship.
No, sir. The amount of gratuity, 1/4 of the emoluments of an officer for each completed year of 6 months, a 6 monthly period of qualifying. So it is going to be 50%. For every 15 days of service, you will be given 1/4.
Yes, Your Lordship.
And maximum of 16.5 times. Yes.
Lord, in fact, these rules are already overridden by the Act of 72, my lord. We are paying as per the Act of 72, my lord, the formula 15 into last
No,
pay.
the rule is 1980.
Correct, my lord.
Rule is subsequent.
My lord, kindly have page 56, my lord. This is the order 56, 56. This is the third round of litigation, my lord. Now, my lord, In a writ petition, my lord, filed in 2017, this is an order dated 8th of December 2020. If I may read one, I'll read the entire order, it's very short.
Yes.
My lord, it reads, my lord, 2 writ petitions are before us. 1 writ petition has been filed by Srimati so-and-so.
What is the prayer in the writ petition?
My lord, kindly have page 57, my lord.
57.
In writ petition number so-and-so, the petitioners are seeking directions upon the respondent's authority to release all retirement benefits, namely so-and-so, the writ petition so-and-so. Now, kindly come to the next paragraph, my lord. Insofar as writ petition number 318...
So you already challenged.
Yes, my lord. And this has been decided, my lord. And it has been...
How was it maintainable?
Observed. It has been...
See,
Your Lordship, when we file this writ petition, Your Lordship, then we only came to know when they file affidavit, Your Lordship, that they have implemented according to Payment of Gratuity Act.
yes.
But Your Lordship, after that, Your Lordship, they implemented only the section 4, Your Lordship. But according to the rule, according to the Act, section 4, subsection 5, Your Lordship.
See, 4-5, it enabled to get a better gratuity,
Yes.
correct, from the employer. If there is a dispute, you will have to get the redress only before the labor court, not before the controlling authority. Though you are entitled to go before the controlling authority, Supreme Court in some bank case, so please get my mobile. Get my mobile. I'll give you the authority. 4-5, if you want to get it agitated, you will have to go before the labor court. The Supreme Court has decided that issue in para 43 and 44. If I remember correct, the judgment is page number 44 and para number is also 44. Should I send it to you? That's the judgment. Division bench judgment in which I was a party, I have authored the judgment dated 21st February 2023. Writ appeal 1947. Mistake, na? Oh, thank you. The other one is sitting singly, I passed an order as early as in 25/7/2019 in WP 21456 of 2013. Wherein I have quoted various judgments. In fact, I have observed that the judgment of the apex court needs to reconsider, but I can't do it. I have who the law of precedent requires that I have to follow the judgment of Supreme Court. Because in given law case, they said you have to go before only the controlling authority. Or when the Act provides certain thing, you have to go get a redress only before the authority. But in this judgment, the Supreme Court has held that you have to go before the labor court. I said, unless this order is taken up by a larger bench and take a different view, Allahabad Bank's case. Single judge, the division bench. 2010, 2 ACC, page 44. And para number is also 44. And 45. 44 and 45. The judgment of this Supreme Court in page number 2010, 2 ACC 44, have the distinction taking into account Padma Sundar Rao case. Because various other judgment, early judgment of Supreme Court has not been referred to by the Supreme Court, which I have referred to in the sitting singly. But in para 45, they specifically mentioned about 4-5, so I am bound by it. That's what I have written. Naraba, it's hit by res judicata.
Yes, my lord.
What is that? No case.
Your Lordship, I'll just pray, let me come on Monday, Your Lordship, let my senior come, Your Lordship.
Who? I'll dismiss you, dismiss the case
Your Lordship, please, Your Lordship.
without cost. Otherwise, if the senior comes, I'll dismiss it. Definitely will dismiss it. If my brother disagree also, I'll impose cost. To pay 25,000 rupees to the Shillong Bar Association.
And this is the third petition, my lord. One petition between was withdrawn.
Dismiss it. The result is going to be one and the same. Post on modern orders for our money. We are disposed of self. We'll dictate the judgment. What was reserved? Pronounce orders on Monday.
Just one more page, my lord. Page 60, my lord, is the compliance.
Page
60, my lord. After this judgment was passed, my lord, page 60 is the compliance by the minister.
complaint order. Yes. Yes, I have noted it.
Yes.
Last week I couldn't read the papers because lots of guests. Yesterday I was free, so I read all the papers. What is reserved? What shall I post on Monday? Post for orders on Monday.
Amresh.
Yes. Madam, send it, I'll dictate you.
Item number
Take
5.
out that civil judge.
This item number 1.
You read our judgment, where in love affair, we have reduced the punishment, where it proved love affair. Yes.
Your Lordship, the
Where is
petitioner
the affidavit?
will file in the course of the day, Your Lordship. Will be filing in the course of the day. I pray that this matter may come up on Monday then, Your Lordship.
The matter was heard in detail. Full stop. This court expressed its view that the petitioner has no case and the writ petition will have to be dismissed. However, in order to give an opportunity, since the petitioner is taking care of the child and old age person at residence, this court suggested to the respondent to provide a breathing time for the petitioner to join the transfer place. It has been stated that the order of transfer was issued as early as in February 2024. February, no?
January, Lordship.
January 2024. And that the petitioner has not joined the transfer place, even though she was unsuccessful before the Central Administrative Tribunal.
Lordship, release order also has been issued. Lord.
Huh?
Release order also has been issued. Release order also has been.
It is further stated by the respondent that relief order has also been issued. Full stop. Normally, when the court dismisses the matter, will grant time for the party to join the transfer place. In order to give a quietus to the matter, we suggest to the petitioner to file an affidavit within which time she will join the transfer place, so that there will be no further litigation on the issue in question. The counsel for the petitioner would submit that she will file an affidavit on Monday.
Today, Your Lordship.
Today.
Today, Your
To
Lordship.
file the affidavit during the course of the day, seeking 3 months' time to join the transfer place. Pose the matter for orders on Monday. Yes.